Christopher Renwick should have not only found that Detective Grus was not guilty, based on this decision alone, which he actually relies on, he should have also found that there has been an obstruction of justice in preventing Detective Grus from probing further and suspending her. That is an obstruction of justice of the Ottawa Police Service executive to stop Detective Grus from probing into the reason why there was a doubling or tripling of infant deaths between 2021 and 2022.
Many of you may be familiar with the case of Ottawa Detective Helen Grus, known as a rock star investigator who was found guilty of discreditable conduct by way of a nearly 3-year-long disciplinary hearing last month. Her crime was daring to question the reasons around suspicious infant deaths happening concurrent to the rollout of the novel modified RNA COVID-19 vaccines. Questions, I might add, that persist to this day. Hearing officer and retired superintendent Chris Renwick ultimately determined that Grus self-initiated an unauthorized investigation and that she did so based on a personal interest. But Grus's lawyer, Bathsheba Vandenberg, says the decision is riddled with inaccuracies, and the case law referred to and relied on actually proves Grus's innocence. Let's break it down here.
An adjudicator's job is to be very meticulous and to look over the evidence and then to look at the elements of the charge and to state at which point the evidence meets that threshold for the charge. And then there's the whole weighing of the evidence in terms of reliability and credibility. And that has not been done here. There have been conclusions made against, I say wording, it's not even an allegation because it wasn't part of the charge. To state that Detective Grus is guilty based on her personal convictions is essentially what this decision says, is wrong. It's wrong because that's not part of the charge and it's not in the statute. And so this decision, in my view, is a decision that goes far beyond disciplinary proceedings in the charge. It actually further blames and shames Detective Grus for standing up. And I say that because at the outset of the decision, the hearing officer states, well, I'm not going to deal with a whole lot of irrelevant evidence that the defense proffered. And he doesn't go on to state what evidence was irrelevant. And yet he includes analysis here on information that is not evidence on record and on information that is certainly not related or relevant to the charge. And that information is in particular the bullying and the ostracization that Detective Grus faced. And this decision actually just further shames her and blames her. And it states here specifically that Detective Grus sent unsolicited messages containing self-researched medical data and studies to OPS personnel leading and managing pandemic responses and protocols. Now, when I state that, I just want to say that I feel like the hearing officer took the closing submissions of the prosecutor and copied and pasted them into his analysis as very disconcerting, because I raised the issue of the Brown and Dunn rule, where the prosecutor was making conclusions on information that was not in evidence, that was not put to Detective Grus in cross-examination, and that is simply not allowed. And then the hearing officer goes on to adopt those conclusions when that information was not put to Detective Grus in cross-examination. And to focus on on that part of the prosecutor's submission and to adopt that, and then to go further and saying that in doing so in sending these messages, Detective Grus eroded the support of her SACA colleagues and professional relationships became fractured to such an extent that her sergeant and staff sergeant gave her specific direction not to debate COVID-19 policy within the SACA offices. I find that statement shaming and blaming Detective Grus. It further exemplifies my concerns that I raised that she is being bullied. She was being bullied, and this decision is another example of police officers being bullied when they stand up for ethical principles. They're being bullied by the executive, they're being bullied by their chain of command, and they're being bullied by the hearing officers, which are designated and appointed by the Ottawa Police Service.
This shaming and bullying played a key role in Grus's silence, and it's a key component because hearing officer Renwick found her guilty even after extensive testimony and cross-examination revealed that she repeatedly tried to bring concerns up her chain of command and was ultimately silenced and intimidated out of doing so by the upper brass at the OPS.
Guilty because she didn't seek authorization from the executive to look into issues that may or may not link to liability of public officials. Now, the thing is, it's very important to understand that there's no evidence on the record that Detective Grus was actually investigating criminal liability of public officials. That's not part of the charge. She's not charged with investigating liability of public officials. Right? She's concerned on the doubling or tripling of sudden infant deaths and in unusual circumstances. And she's just at the probative stage. There aren't any conclusions drawn. She never drew any conclusions that there were links to the COVID-19 vaccinations. She couldn't at that time in 2022. And that's what's wrong with this decision as well, is it repeats that she did make links between COVID-19 vaccinations and was looking into the criminality of public officials, which is not true. The charge is within 2021, 2022, right? And it's in her interview, in her compelled interview of May 12th of 2022 as a citizen of the public, where she comes across this Pfizer material, the clinical data that shows that the COVID-19 vaccines weren't tested on pregnant or breastfeeding women, that she starts to raise a concern as a citizen of the public of potential criminal negligence. But she never stated that she was looking into criminal negligence already in 2022, January 2022. She just simply didn't have that information, and she was just probing. And so this decision is telling police officers, when they have concerns for public safety, when they have concerns for preserving life, that there's something out there that might be impacting the lives of Canadian citizens. This decision is telling police officers, you can't look into that. You actually don't have the police discretion to look into that, especially when it involves public officials. Now, I can't answer the question of which public officials because it was the prosecutor that mentioned that. It was a prosecutor in her closing submissions that mentioned that Detective Grus was not allowed to do this investigation because it would have implications of liability of public officials such as municipal, provincial, federal government. We never made those submissions. They were never in the opening submissions of the prosecutor, the charges. It was not something that was examined during the disciplinary proceedings. It was put into the closing submissions of the prosecutor, and then it was picked up and further developed by the hearing officer and threaded throughout his decision. And that's really a pity because it's damaging to police discretion. It also is fundamentally dangerous to our rule of law. This decision has dismantled our rule of law here. I am deeply concerned as a Canadian citizen as to my own safety in this country. And I know this case focuses on Detective Grus looking into a doubling or tripling of sudden infant deaths, but the impact of this decision on police discretion, on the fact that police are not allowed to investigate public officials, tells us that public officials are above the law. So government are above the law. And we already see this trend in Canada. Well, it's been reinforced by this decision saying that police officers are not allowed to investigate.
This chilling pattern of one law for me and one law for thee here in Canada seems further reinforced by the fact that Grus had an exemplary record and that her evidence proved she was innocent.
The hearing officer actually says her evidence is exculpatory. He states it twice in the decision. He states that she's a credible witness, that her evidence is exculpatory, and yet he finds her guilty. Remembering the standard of evidence for police disciplinary is higher than a balanced probabilities. It has to be on clear and convincing evidence. Well, if Detective Grus, the one who's the respondent to this internal police complaints, is found to be credible and her evidence exculpatory, then how did the hearing officer draw the conclusion that she's guilty? That doesn't make sense.
Vandenberg says another thing that doesn't make sense is Renwick's reliance on a Supreme Court of Canada decision to back up his assertion that there are limits on police discretion, which he doesn't outline what those are in this decision, but Vandenberg says he used the case law entirely inappropriately and inverted the decision.
Let's turn to the Supreme Court of Canada case that talks about limited police discretion. Well, it actually doesn't say to limit police discretion. This is a case where a police officer failed to gather evidence to help put together a charge against another person because of preferential treatment. The preferential treatment was because the person was also a peace officer.
The case in R versus Baudry, specifically paragraph 46, says that police policies speak to the manner in which police should carry out their responsibilities, but do not define or limit those responsibilities. And Vandenberg continues to poke holes in this reliance.
And it is important that they remain independent of the executive branch. That's the Supreme Court of Canada and the case that this hearing officer quoted in the decision finding Detective Grus guilty. And then it states, the court continues to state that in discharging their respective duties, both the police officer and the prosecutor have a discretion that must be exercised independently of any outside influence. There's more. It gets better. I mean, this is a great case to be quoting, and it shouldn't have been quoted to limit police discretion. At paragraph 51, the court states that police discretion is an essential component of our criminal justice system. It would therefore be paradoxical to say that conduct that tends to defeat the course of justice can at the same time be justified as an exercise of police discretion. I would argue that this decision, so it's not just the charge now, we have a decision now, that this decision is actually undermining and defeating the course of justice. It actually should have the superintendent, Christopher Renwick, the hearing officer, draw the conclusion that Detective Grus is not guilty because there is a positive obligation on police officers to use their discretion, their police discretion, to protect the public and to preserve life. And when they fail to do that, they are obstructing justice. That is what this decision is saying. That's what the Supreme Court of Canada states. And so, actually, Superintendent Christopher Renwick should have not only found that Detective Grus was not guilty, based on this decision alone, which he actually relies on, he should have also found that there has been an obstruction of justice in preventing Detective Grus from probing further, in suspending her. That is an obstruction of justice of the Ottawa Police Service executive to stop Detective Grus from probing into the reason why there was a doubling or tripling of infant deaths between 2021 and 2022.
While this appears to be a solid basis for an appeal, Grus must first navigate a few procedural steps. First, a penalty hearing, which is similar to a sentencing hearing, with the defense requesting it to be in person. The prosecution is said to be pursuing a demotion, which is contrary to Grus's position as a first-class constable, currently in the robbery unit since 2022, and her eligibility for promotion, something Vandenberg calls cruel and unusual, before outlining next steps.
The next step is to appeal to the OPAC. So the OCPC has not yet been dissolved, but can no longer hear appeals under the new legislation. And so we will be going to OPAC. And then the step after that would be divisional court if there's a need for a further appeal.
So here we are with a rock star Ottawa police detective being dragged through a 3-year-plus disciplinary rigmarole with her exemplary record tossed aside, branding her guilty of discreditable conduct despite impeccable evidence. The leaning on a warped Supreme Court of Canada decision flat out says police policies guide how cops do their job, not what they're allowed to investigate. Yet Grus was silenced, bullied, and hung out to dry by the brass for raising red flags up the chain of command. If this isn't a glaring neon sign of Canada's two-tiered justice system, I don't know what is. For Rebel News, I'm Tamara Ugolini. I hauled myself to Ottawa multiple times to attend this trial in person because someone had to. The mainstream media went radio silent after pressing the Ottawa police to do something about Grus, arguably initiating this entire mess, but left the real story buried. If you value our boots-on-the-ground effort to bring you the unfiltered truth about Helen Grus's fight, I'm asking you to dig into your pockets and toss a few bucks our way to help cover my previous travel costs and future ones. Please head over to rebelfieldreports.com and chip in whatever you can there. That's rebelfieldreports.com. Thank you in advance for your support.